From the News Channel 5 Network, this is MorningLine with Nick Beres.
Good morning, everyone. Thanks for joining us on MorningLine. Nick Beres with you on a Tuesday. It's good to be here, and I'm glad you're with us. We've got a good show on tap this morning. As we've started doing periodically now, we're going to have programs where we focus in on some of the high-profile criminal cases that are going on here in Middle Tennessee. We'll take your phone calls, get into a lot of some of things that are happening and new developments on these cases. And as always, take your phone calls, 737-7587. I know a lot of you have quite a bit of interest in many of these things. And there's some new developments and new cases that have just come up. To talk about it, of course, we're getting the band back together. Yeah, I mean, News Channel 5 legal analyst Nick Leonardo is here with me, and it's good. We should have done this a long time ago, have you on as a regular guest every month or so to just come on and talk about a lot. And there's always cases going on.
As you said, high-profile cases. I thought, what makes a case high-profile? And I thought, well, it's because Nick Beres is covering it, right?
Well, it's the two of us, Nick and Nick squared. No, we do. The media has obviously a role in making things high-profile, but it's the media coverage that comes around it. There are a lot of crimes that I wish we could cover and we don't. And that gets to one. I've had a lot of emails and messages from folks wondering whether or not we're going to do gavel to gavel on the Gabby Doolin trial. And that horrible case, the 7-year-old raped, sodomized, murdered 4 years ago. That trial finally scheduled to begin in Allen County, Kentucky. And it's actually going to be change of venue over in Hardin County, Kentucky. I think the September 4th or 5th is when they're going to start jury selection. We will not be doing that gavel to gavel for a lot of reasons, but primarily logistical, the distance and what it would take to get that up and running. We will be covering that case. It just won't be gavel to gavel. But for a lot of folks, they're like, gosh, I thought that case was already resolved. 4 years, Timothy Madden has been locked up, the prime suspect, going to stand trial. But finally, now 4 years later, why did it take so long, Nick?
Well, I believe, I think we discussed this the last time, that there had been new defense counsel was brought on board, and I think there's actually a new DA that was brought on board. And so in a case of this magnitude, it takes a while for those folks to get up to speed. So whereas you might have had the prior defense counsel was ready to go to trial, but something came up, there was a conflict, and so they had to get off the case. And so it's going to take new counsel, some time to get up to speed, plus the court has to logistically figure out when they can fit this trial in with everyone else who is incarcerated awaiting trial as well. So
when you say magnitude, everything gets more complicated when you seek the death penalty. I'm not saying you shouldn't, but death penalty cases, and if you've followed some of our coverage on some of these cases that we've done in the past, changes everything in terms of it just lengthens the process, does it not?
Well, and absolutely, because you want to make sure that you give this criminal defendant, because he's facing death, every possible due process they can get.
You've said that before, but wouldn't you do that if they're facing life in prison? I would think the defendant and the prosecution should get every opportunity to handle things right. Well, what do they do so much different on death penalty?
Well, I mean, for example, number one, you have to have a death qualified attorney appointed to do that. But let's be honest here. If there was a wrongful conviction, then that person, a few years later could be let out. But if this person has been killed by the state, and we find out we killed the wrong man, I think that's implicitly in the school of thought of everyone who's involved in the death penalty cases. But it's very, very expensive, to put someone to death. And quite frankly, we're seeing now that there's a 25, 30-year lag time. However, I do believe the General Assembly just passed new legislation that cut out one of the appellate levels there on death penalty cases. I think now they go straight to the Supreme Court and bypass the Criminal Court of Appeals, the intermediary, so that may help speed the process up and a little bit more.
Yeah, I think the governor did that with regard to the prosecution of the suspect in the case of Officer Baker there, who was murdered in Dixon County, I believe. Horrible case, and they wanted to move forward. They're going to seek the death penalty on something like that. Now, it does get into a larger question. I wonder what some of our viewers think. So often in these cases, and the most recent one now that we're going to talk about is the situation with the death of Deborah Johnson, the corrections administrator who was found sexually assaulted and murdered in that case by the suspect. Curtis Watson was on the run all those days. They've got him in custody, and a lot of people just assume that's a no-brainer. You kill a law enforcement officer, a corrections officer, you're going to get the death penalty, and certainly it qualifies. But that doesn't always happen. They don't always seek the death penalty, and they may not in this case. I don't know how her family feels. Does that count?
Well, I mean, absolutely. You know, in Tennessee, we got the Victims' Rights Amendment, and that means that the district attorney of that elected jurisdiction, he's going to have to, you know, apprise the victim's family all along the way of what's going on in the case. And so, again, it's his unfettered prosecutorial discretion as to whether or not he wants to seek the death penalty or make this a capital case. But, you know, if the victim's family is somehow diametrically opposed for religious reasons or otherwise, I think the DA certainly would take that into account. But you also have to remember, too, that there's not a lot of closure with death penalty cases. As you see, you know, the appeals keep coming up, the media keeps covering it. You know, he gets put on death watch, people are outside the prison, you know, and the mugshot continues to pop up on the screen, whereas if the person got life in prison, we're never going to hear from them again, and probably there'll be nothing newsworthy. So I think it makes closure sometimes even more difficult on victims' families. But I do think that the prosecutor would certainly take that into consideration in determining whether or not to pursue the death penalty.
You know, we saw that in the Holly Bobo case, didn't we?
Correct.
I think ultimately, after Zach Adams was convicted of killing Holly Bobo, you know, his attorney got with the family or whatever, and they worked out a deal where instead of pursuing the death penalty, he accepted life in prison without parole. And I think one of the reasons may well have been, look, all right, let's lock him up, we're done with it, there aren't any more appeals, he's out of there, even though he is appealing his conviction at trial, but he's accepted this. It's not like death penalty, which one after another, and we've seen it time and again. We just had an execution, but he'd been on death row for over 20 years, just this past week. And so I think too often people think, and I think the DAs initially say, oh, we're going to seek or consider the death penalty because politically it sounds good, because everyone's furious at this crime, but it's not always the best way to go necessarily.
Well, and from a fiscal note, it's much more expensive to execute someone than it would be to just incarcerate them for life because of the appellate process. I mean, you know, typically you have a three-tier appellate process in Tennessee. You got a direct appeal, you got habeas corpus, and post-conviction. And post-conviction is where you say you didn't have a good lawyer, your lawyer was ineffective. Well, if it's a capital case or a capital conviction, there's a whole office dedicated to reviewing a lawyer's performance under post-conviction procedures if it's a capital case. Whole office, okay, of government paid, you know, employees on the defense side of things. And so there's a lot of money tied up in pursuing execution, and there's no doubt the framers intended it. There's no doubt that we have it, but I think that it's turned in. I don't think they would believe that it would have taken 25, 30 years to execute someone. So I do believe that part of it has changed, and I think a lot of states, we saw California commuted everyone's sentence, the governor did. So
well, after they executed a few people, as you said, and they found out, oh, they didn't do it, you can't take that back, can you?
Well, that's exactly right.
Yeah, that's a big deal. Getting back to just the Gabby Doolin case, we'll touch on several, and we'll open up the lines if you have some you want to ask questions about, just about the legal process. Nick's the man to answer it for you. But with the Doolin case, you know, I've gone back and reviewed some of the information as we were preparing to do the coverage of it. And again, we're not doing it gavel to gavel, but we'll be covering the trial itself. The evidence in this case is interesting. It's been 4 years, all right, and you know, supposedly what was released early on is that there was DNA that linked him to the crime, and supposedly whether his DNA or her DNA, some may be found on him, maybe some found on her. The details of it have been sketchy, and it's been retested time and again. And as far as I can tell, there is some type of link there, but they say it is not a strong sample. Again, I don't know for sure. I haven't seen the evidence file myself, but that's what I've heard. What does it mean, maybe, if you think there's a DNA link, but then they say, you know, the problem here is it's not a strong sample. They have to have more to bolster that?
Well, so a lot of times what we see in the DNA, you know, findings is that, you know, there's a 99% chance, you know, essentially that this is exactly this person's DNA. But sometimes you see them come back at 60%. Other times you see, you know, there's the suggestion that maybe it was contaminated. You know, this particular sample wasn't kept in the kind of condition it needed to be kept in order to have it tested, or maybe it would be consistent with another individual, and that's what they would be arguing. And so, I mean, obviously, if you're at that 99, 96%, I think that's kind of overwhelming for a jury, but at 60%, I think there's a lot that the defense could do to suggest that, you know, I mean, it might not be him, or it could be consistent with someone else, or maybe it was contaminated. That's
what I have to wonder, because I having not seen the case file, but we know he's pleaded not guilty, and Timothy Madden said he hasn't done it. Now, I've said all along, if they found a strong sample, say, of his semen or blood on her, it's over.
I think so.
It's over. That's all you need. He's done. He's convicted. And that's why I'm thinking, if that sample is not strong, that's why they're mounting a defense as opposed to trying to work out perhaps some type of plea deal. Because if it is a strong sample of his DNA on Gabby Doolin, if I'm on the jury, I don't need to hear anything else.
Well, and
unless you want to say it was planted.
And in
or
those
something
set
like
of
that.
facts, you're absolutely correct. But if you're talking about Joe Clyde Daniels, DNA is not that big a deal because obviously you live with this individual,
Right.
that you're related. It's your son, it's, mom, dad. So DNA, everyone's DNA is all over everyone else because they share the same home. But in that set of facts, I think you're absolutely right.
Yeah, but again, because of that, and I know his attorney is challenging it and has retested the DNA. Another part of it, and we'll talk about this when we come back from the break. We'll take some calls, and it's a larger picture on a lot of these cases. Insanity defense or diminished capacity. I do know, finally, with these new lawyers, it was just last month that they finally sent Madden to go get a mental evaluation. The results of that not necessarily back. He's deemed competent to stand trial. That doesn't mean that his attorney potentially, and his attorney hasn't said, couldn't seek a diminished capacity or insanity plea in that.
Yeah, but
right?
that TV interview doesn't help him. He seems pretty lucid.
Yeah,
it always comes back to that, doesn't it?
Very lucid. There is one other case, though, where of all of these, I feel that insanity could really have a strong grounding and maybe a successful plea on that one. And I'll tell you what that one is. You can tell me if you agree. But we'll take some calls as well. 737-7587 is the number. If you're on hold, stay there. We'll get to your calls. More with Nick Leonardo. He is a fine attorney. Right after this.